SEC has a much broader, or the regulatory side on the RIA is within reason. And it has to be, do you have a duty of care and a duty of loyalty on the RIA side, which you already have if you hold your Series 63. But that becomes your guiding principle if you're RIA only. It's not, there's a specific rule on this date at this time, it's this way. Rather, the SEC rule is, am I doing what's in the client's best interest?
Welcome, Model FAs. David DeSalle here, president of Model FA and your host of the Model FA podcast. And we have a very relevant show for you today. So I'm welcoming Michelle Atlas to the show, and she's a part of a company called Advisor Law. And with more and more advisors going over to the RIA space from a broker dealer, I thought it was important to have Michelle on to help walk through some of the things to take into consideration when making that change, things to be on the lookout for. And Michelle is more than credible to deliver some insight on this topic. She's been an attorney with over 20 years of industry experience and now runs the RIA division over at Advisor Law. So excited to bring her to all of you. Michelle, welcome to the show.
Thanks so much, David.
Of course. So before we dive into some of those topics you had alluded to in one of our previous touch points, spending some time abroad. And, as I mentioned, you're probably not graduating college and then getting into advisor law right away. So help walk us through kind of your career journey up to this point.
Sure. I always thought I would be a lawyer, so I do have a degree in philosophy, which what else are you going to do with that? But as a younger, wilder person, I needed to get away. So I went to Japan for a year and a half and then spent actually 2.5 years in Japan and then another year and a half in Australia before I came home.
Awesome.
And then when I came home, I needed a job. And my mother, just like many of your listeners, their son or their daughter or their sibling works with them, particularly in the independent channel, but certainly wirehouse guys bring on their daughters or their sons as well. My mom was a financial advisor. So I started out wholesaling variable annuities with Transamerica when I got back from being overseas. I figured I could sell. I wasn't sure if I could or not, but that was how I got into it. And I didn't want to work every day with my mother. I don't know if you have, anybody out there has a wife or a daughter or a sister, probably doesn't want to work with her mother. So people have always asked, well, why didn't you end up with your mom? Well, it's my mom and I'm her daughter. Nothing against her, but my brother did join her in the business and he now has her book and she's retired. So that's that family element. I was a wholesaler with Transamerica, with Jackson National. On the inside, I trained on annuity products. I trained wholesalers as we released new products. And then at some point, I realized I hadn't gone to law school, and that had always been my plan. Unfortunately, at that point for me, I was already 40. So I did go back to law school at 40 while being a compliance officer. And then I've worked in litigation and in-house at an independent broker-dealer, worked with a lot of customer complaints and focused on that for a little while, got that experience. And from there, met Dr. Kennedy, who runs Advisor Law, founded it. He's a character, he's a lot of fun to work for, and he's got a lot of fresh ideas. And when he decided that it made sense to open this division, he put me in charge of it. And I'm grateful. And we've learned a ton and we're doing a lot of great work. And it's been a fun journey.
And you guys are essentially like an outsourced compliance officer for firms, or help me understand.
We help draft contracts with their IARs if they need them. If they're going to sell their book, we draft those contracts. But our main service is ongoing and continuing support at various levels.
Okay, cool. So I came from the broker dealer space. I was with Northwestern, and when I left and got into consulting, I noticed that there were a number of folks sort of getting out of that particular bubble. As I got to know more about the industry, I noticed more and more folks from wirehouses, other broker dealers, would end up making the transition and either joining or starting their own RIA. When I was talking with those folks, one of their biggest concerns was they had a lot of BD related business as a part of their books, and they were hesitant to go fully RIA and totally dropping, their broker dealer affiliation. Um, Help me understand, when you work with advisors that find themselves in a similar conundrum, what are you helping advise them on during that transition? What are some things for them to take into consideration?
Sure, there are quite a few. And I would say sometime in the 90s, people started doing more and more what they would call managed money, and they had to get their 65 in order to do that. So more and more of your wirehouses or your traditional broker dealers, their individual representatives are duly licensed. They may not realize it. They just know, in order to do managed money, I had to take the 65. So they have a BD and an IA relationship with these duly licensed entities where they work. So what they're able to do, they don't need a new license, but they need to think about what kind of products have they been selling, what kind of clients are they helping, and how are they helping those clients. More and more things have moved from a brokerage account where you're trading the client's individual stocks, right? Typically, people are using third-party managers, or they're designing their own models, and all of that is advisory work. Anything that you collect a fee on is RIA. Anything you collect a commission on is broker dealer. And so you look at your book and you say, well, what else am I still collecting commissions on? Maybe it's variable annuities. That's an area where you might have trailing commissions that you've had for a long time. And some of those variable annuities you really can't touch because they're in the client's best interest to leave them alone. They need those guarantees, and they're at lower prices. But others, maybe they no longer need the certain guarantee that they had. Maybe their kids are grown up and they aren't as worried about the death benefit provision. Or maybe they were married and they had a joint rider, but the marriage has ended and they no longer need that to be a joint rider. So they need to move out of that product. What's happening in the world is there are a lot of variable annuities that offer a fee-based option, and there are a lot of variable products that you can look at and work with a third party who has the insurance license and where you can collect a fee. There's a few of those out there that we can certainly recommend. But on the other hand, some people are saying, okay, I've still got this book of this many variable annuities that are going to be broker dealer, and it's not in the client's best interest to move them. So they're either selling those or leaving them for a fee. There's a lot of different ways around that. The other product that we run into trouble with is 529 plans. They don't collect a lot of money. Sometimes you should have a whole client relationship. And what happens is your client has $8 million with you, but they also have 3 grandkids and these 3 529s that they put $100 a month into. And those really can't be fee-based. They have to be A shares. Those types of products are harder, and you have to decide if helping the clients with that is worth it to you to stay in your current situation. You may not leave, but banks offer those 529s, and the commission that you make on $100 a month for 3, if you don't have a lot of that business, it might be worth it to just say, either I'm going to sell it to a rep that's staying, or I'm going to work with my clients to go to the bank that they currently use and sign up for the 529 in their state. So, and I'm not going to get paid on that. It's going to be part of my advice and part of my planning, and it will be rolled into how I'm earning money off that entire agreement. So there are some challenges, but I think 90%, 85% of most people's books these days, if you look at them, are fee-based because they are using managed money. They are using third-party managers. They are using what have been referred to as separately managed accounts. And when you're doing that, all of that can be done under the SEC or your state securities division, you don't need a broker dealer. You don't need FINRA to be involved in your life. And that's where people are saying, okay, I'm going to have to give up a little, but the upside is so great that it's worth it to either leave those accounts or sell those accounts.
So let's talk about that last piece a little bit more. And it sounds like from what you're sharing, what may have been a bigger issue based on where the industry used to be in terms of percentage of business and managed money versus, with the broker dealer is now not as big of an issue because the industry has shifted throughout the years to be more managed money. But I guess my question is let's start to talk through like how the benefits outweigh some of the drawbacks or loss of revenue. So when you drop FINRA and no longer affiliate with a broker dealer, what are some of those benefits to the advisor?
Well, there are a lot of benefits. One of the most basic, obvious ones is you no longer have to pay your annual registration to FINRA as an individual. That's depending on how many states you're in, that could be a $2,000 to $4,000 savings. It's not great, but there's a lot of things that come with FINRA registration that you're required to do. There's continuing education that they require. There are audits that they require. They can come in and they have jurisdiction over you. And FINRA is a regulator, and I'm not going to bash regulators here as much as I would love to, but having less regulation over you is better than having more, right? Because they can come in and they can look at things. They can have certain topics that they've decided are a problem, and they're going to come in and look at everybody in your state that's selling a specific product or doing a specific thing. And you're really just taking away one regulator, and because the state still always has authority over you when you're selling things to clients in their state. And the SEC, if you have over 100 million under management and you're registered with the SEC also has complete jurisdiction over you. So when you're looking at FINRA derives their jurisdiction from the SEC. So instead of having 3 regulators, and if you're doing insurance, maybe 4, you're down to 3. So I can't give you a specific, this is what it's going to save you in compliance time and resources, but it's definitely going to reduce the regulatory oversight. And then in addition to that, FINRA rules are meant for the masses, if you will. FINRA has regulated, you can only have $100 worth of a gift to a client. They have a rule about gifts. Whereas the SEC has a much broader, or the regulatory side on the RIA is within reason. And it has to be, do you have a duty of care and a duty of loyalty on the RIA side, which you already have if you hold your Series 63. But that becomes your guiding principle if you're RIA only. It's not, there's a specific rule on this date at this time, it's this way. Rather, the SEC rule is, am I doing what's in the client's best interest? Am I being careful with their money and making decisions I think are careful? And am I then doing what I would do if I was standing in their shoes with my knowledge for them? And every rule kind of comes back down to that. And it becomes, if you can make a solid argument that what you're doing is reasonable, you don't have to follow a specific rule. So it's harder that you have to say, this is my business and this is what I'm going to do for my customers, and I'm going to make it reasonable that I do it. But you don't have the nitpicky specific rules that you would have in FINRA.
Understood. So it seems like it's, save some money and then just a lot less scrutiny over, particular line items. And I think one of the comforts of being with a larger company, if I'm an advisor, is that to a certain degree, obviously I need to take some ownership around making sure that I'm doing, what the laws are and what's in the best interest of my clients. But to a certain degree, I have a compliance department that backs me up. And, that's where you guys come in, where if someone goes and opens up their own practice in the RIA space, they can partner with you guys. So on that note, what are some of the trends that you're seeing in the RIA space, specifically from a compliance standpoint, that perhaps some of these newer advisors, and when I say newer advisors, I mean newer to the RIA space, should be aware of? What are some of those trends?
Sure. The regulators are always moving the bar. Unfortunately, that's how we see it from our perspective. The SEC marketing rule came out a couple of years ago, and that gives a lot of opportunities for having your clients give you a Google review or to provide a review about you on their LinkedIn page. Those used to be prohibited, but now there are rules around allowing that. A lot of FINRA members still aren't allowing that because they're concerned about the FINRA rules. But there's a lot more freedom in that rule. It's very streamlined and specific. They were getting a lot of feedback. The rules, that we follow were written in 33, 34, 1940, right? And so the world has changed so much. That the marketing rule was an SEC attempt to get caught up, and mentioned Google reviews and things like that, and how to make those work. So taking advantage of those new freedoms, but still staying within the way the rule is written. And it's a 420-page rule. I don't know anybody that is a lawyer that really wants to read it, but I know everybody that's not doesn't. So helping to distill that and look at things like that. Further, there's a lot going on in the cybersecurity world and helping to decide what do I need as an independent small business owner to have the right cybersecurity options and protections in place, guidance that we can provide on, you need E&O insurance, but you also need cybersecurity insurance. And what does that look like? And what's enough for what you're doing? And then beyond that, the DOL just in May there was a state court case in Florida where a section of the DOL's guidance was struck down. And so really that law has been going back and forth since 1974 and changing and growing, and Obama administration suggested something, Trump administration changed it, the courts have now changed it again. And so we keep up on all of that, and we make sure our clients' policies and procedures, their manuals, their documents, stay up with those kind of things. So there is a lot of work around being your own chief compliance officer. And if that is frightening for you, we have an outsourced option. But our main line of what we do for our customers is keep them in line with all of the types of things that are changing, both good and bad. Like I said, I think the marketing rule really provides some great opportunities in the changes. And so sometimes I'll hear from somebody, oh, we were never allowed to do that. And I'm able to say, yes, but you can now, right? It's not always taking away. Sometimes compliance can give.
Well, it's funny because and I want to hit on the marketing stuff some more, but when you look at our industry and you compare it to any other industry, right? Any other industry, be it, software or engineering or construction or whatever, right? They can market the way that a business should be marketed in today's day and age. And when we work with the RIA space, it's fun because we get to deploy all those things that are working right in 2023. Whereas when we go to the broker dealer space, some of them are more up to the times than others, but some firms don't even allow their advisors to like a post on LinkedIn because it's viewed as, or it could be viewed as, an endorsement. And I had a friend who was hired at a particular firm. I won't name names, but he had to go and unlike all of the previous posts. And I'm just like, that is, excuse me, but that is so dumb.
Yeah,
And
we worked on our litigation side with a guy who, from his personal Facebook page, liked and commented something on somebody else's page. And it was against company values. I'll give you that. I don't remember specifically, but I was like, that's kind of ugly. But he got terminated for it.
wow.
for something he did on a Sunday night with a glass of wine in front of his Facebook
Wow. Yeah, so I
from a
guess it's just
broker dealer.
yeah, and I guess my point is from a marketing standpoint in the RIA space, it's just nice that you can market your business more in alignment with the way that businesses are marketed today. And even things like, I moved to Florida a few years ago when I started, finding various restaurants and places to go. Like, first thing I would do is read the reviews on Google and Yelp. And just now, right, we're getting access to, that ability, which is just, it's nice that they're finally waking up. And I guess outside of the reviews and maybe the use of social media, anything else that we need to know about the new marketing rule that would be helpful, or does that pretty much encompass the new marketing rule?
Hypotheticals are an area that you have to be really careful with. If under the new rule, they're very specific. If you're going to provide a hypothetical, um, it needs to have certain time periods shown, and it also has to be net of fees. You can't show a hypothetical. If you're going to show gross of fees, you also have to show net. And that's something that we run into. People want to say, you put in $10,000 in this year and it reaches $100,000 in that year. That's fine, but where did the fees affect it? And certainly, if you look at insurance hypotheticals or some of the other things we've used in our careers, net of fees is very fair in the RIA world because the fees that your clients are paying are generally lower than traditional commissions as well. So it's not a harmful thing, but it's about being transparent. And you can't lie, you can't mislead on purpose. You can't say, come in today and you will get a special deal,
Yeah,
right? We still aren't used cars dealerships, right? But it's widened tremendously in this space.
cool. Yeah, I have a client of mine. His name's Amir. He uses a service called I think I shared it with you guys, called Wealth Tender, that helps with the compliance process specifically around reviews. And that's really helped decrease his sales cycle and build trust on the front end of a prospect relationship by just pulling up, when they're on the screen together, hey,
Right.
here's the various reviews I've gotten, and I'll send you the link afterwards. And it's just cool that you can actually guide people towards positive reviews rather than some client or some prospects ask for like a client reference, and then there's
Right.
an issue of like taking up your client's time, confidentiality, things along those lines. So I'm glad that they're finally waking up to it. But I guess, one of the last things I wanted to go through today is, I think it's a fair statement to say that advisors get into the business for, I call it the 3 I's, is what I was taught when I was an advisor: impact, income, and independence. And no one gets into the business unless it's someone like yourself, because they want to be involved in compliance, right? So that said, what are some of the big things that, if I'm an advisor, I need to look out for, because the SEC has been finding these things in, particular audits that they're doing? Like, what are some of those things? That way, myself as an advisor listening to this can be sure to avoid those.
One of the biggest one we saw last year was they were looking at the new Reg BI, and it affects broker dealers in some ways, but it also has requirements for RIAs. And one of those is the ADV3, or what's referred to as the CRS. And it's the customer relationship summary. We had something like, when I compiled them from our SEC audits last year, 30 different types of complaints or deficiencies around that CRS. It's only 2 pages. It's very clear what it's supposed to say, how it's supposed to be laid out, and yet they're really nitpicking it. It needs to be a new date on it every year because you need to review it every year and make sure it's still correct. And when you do that review, you need to change the date. It needs to be on your website, and it needs to be not buried behind 3 clicks. It needs to be read. Your ADV and your parts 2 and your CRS need to be 1 click. If you have to click 3 times to find it, that's going to be considered a deficiency.
Mm.
There's a lot of really, like I said, nitpicky things about font, and all of those things are described in how you create it. But if you create it and you aren't reading through the instructions carefully, they are just, for no unknown reason, being ridiculous about that. So that's the first one I can think of.
And is that like, I would imagine when you're working with someone in a transition, they don't need to go and find this stuff out themselves. You kind of give them like a guideline of, make sure you do this, look out for that, and making it easier for them, I would presume.
Yeah, there are a lot of steps if somebody decides they want to move. And we can help them with, are they a member of protocol right now? If the firm they're with is a protocol member, when we register their RIA, we can make that RIA a member of protocol as well to make that transition easier. We can analyze their contract and look at their non-compete, non-solicitation, help them understand what they can and can't do to move their business. So there's that first step. And then once we give them a certain list of things, like I said, deciding on which custodian or finding their own insurance, but we do have references, of course. Then we do a lot of the heavy lifting. We will help them create their ADV. We will create their 2A and 2B by talking with them and understanding them. And there are companies out there, our competitors, where that's off the shelf and they just give you the template. And we don't believe in that. And I know that I've seen a lot of deficiencies over the year or problems in litigation where your documents don't really match what you're doing. And that's a big red flag that you're not paying attention to your compliance. So we like to have conversations and interview people and ask them specific questions so that we can develop documents that actually explain how they run their business and what they do. And we draft those for them.
Okay, cool. So this was helpful. It was insightful. And I think, if I were to summarize this in a very simple way, when you go from the broker dealer space to the RIA space, you should experience more freedom, less scrutiny, a higher ability to market your business like you should be able to market your business. However, there's still a decent amount of onus on the advisor to make sure that their compliance is in check because they don't have a broker dealer backing them, telling them what to do. So the advisor's choice is ultimately you figure all this stuff out on your own or you partner with another company. So if I find myself, as I'm listening to the podcast, if I find myself in a position to where I don't want to be the compliance person that figures all this out, how do I get more information on you guys to learn about how we could partner together to help with that area of the business?
Certainly. You can provide a link to our website with the podcast information. It is advisor law RIA is the email address that you can use, advisorlawria@advisorlawyer.com. And our website is advisor lawyer L or I'm sorry, advisorlawllc.com. But certainly if anybody wants to just give me a call, they can get my information from you. I'm happy to talk through it with anyone. And just the key is making sure you have plenty of runway before you make your move so that you can have thought of all the things and looked at all the things and have a plan. If it's somebody with a large book or a team, maybe all of you are producers and nobody wants to be the chief compliance officer. We have an outsourced option where one of our employees will be the CCO on your ADV. They will be that person for your team. Otherwise, we have options where you decide who that person is. And what the SEC looks at is, do they have enough authority and will people listen to them? So if it's not your top 4 producers that are moving that you're going to assign the CCO role, you want to make sure that you show them a high enough title and respect and get them the support they need. And we can provide that support.
Understood. One final question I just thought of. One, big concern with folks that are parting ways from a company is, things like non-competes, non-solicits, things that may prevent or create hurdles anyways, for them to bring their book of business with them. Do you guys help with that process and understanding those contracts that they signed years ago?
Yeah, absolutely. And
Okay.
it's interesting because a lot of people signed them so long ago, they don't even have a copy.
Right.
So
And
we
if
have
they
to help
ask, and
them
then they ask for one,
figure
it
out.
raises.
You can't ask, can I see my contract?
Yeah.
Because somebody will know what's going on. And it's a very still, I always refer to it as like a Jerry Maguire situation, right? Where who's going to get the clients and show me the money and trying to figure it out. So yes, we will, if they have their contract, we'll help them review that. There are other ways to look at their firm's privacy policy about data and certain things that you can discover, like I said, whether or not they're a member of protocol. So we do have a service that is strictly for making sure you do that transition appropriately. And that's again why I say plan ahead, because there are things you can take in certain situations and things you can't in others. And you need to look at your individual situation because it's not standard across the industry.
Understood. Well, Michelle, it's been a pleasure having you on the show. For everyone listening, again, go to advisorlawllc.com, check them out, and excited for our continued work together as well, Michelle. But appreciate you joining today.
Thanks so much, David.
Of course.